Good morning. Yes, morning. Thank you for having me. It's so nice to be invited to be here. It's especially nice to be invited back. This is my second time speaking to you all. So thank you very much. I hope to provide a number of options, kind of food for thought, some things to consider as you're progressing through your U.S. immigration journey. I'm afraid that you will find that there is no magic bullet, there is no single solution. In fact, in the U.S., there is no start-up visa, so to speak. So for those of you who thought that there was a single visa class devoted to your next great thing, your next big idea, I suppose I'll start with disappointing news, and that there is no such thing under U.S. immigration law, at least yet. We are ever hopeful. There have been various things pushed through each chamber of our U.S. Congress, but nothing yet that has passed both chambers, and certainly nothing that has been presented to the president for signature and implemented into law. So what I have to present instead is really a hodgepodge of options and ideas. Some of these will be more interesting to you than others. Some of them, many of them, won't apply to you at all, unfortunately. And so we will have to whittle down together the things that will be of interest and of value to you personally. So I chair the immigration practice at Ice Miller. Ice Miller is a full-service law firm. We have practice areas in most areas of the law. A lot of corporate, a lot of litigation, public finance, and those kinds of things, labor and employment. And my little piece of the world is immigration. And so I represent a lot of companies who are sponsoring foreign nationals, executives, managers, professionals, and others to come to the United States, either on a temporary basis and handle their visa work, but also their green card work. I've been doing immigration work actually even before law school. So I graduated undergrad in 1994, and that summer, in fact, I started working for a boutique immigration firm, and I have been doing immigration work ever since, so about 20 years now. It has changed in some meaningful ways over that 20-year period, but in a lot of ways, many, many ways, it has remained quite stagnant, which is of some great disappointment to those of us who are looking for new ways to engage entrepreneurs and other aspects of the economy that could really stimulate some things. So we have a fair amount of material to cover. I want to talk with you today both about temporary short-term visa options, immediate visa options, but also kind of long-term strategy, green card sponsorship, to give you an idea of what's available and maybe what's not available. So with that, I think it's helpful to provide just a general baseline of who and what are we talking about. U.S. immigration, I think it's helpful to think about types of classification in really kind of three different areas. There are non-immigrants, which is frankly, if you're here as a foreign student currently on either an F1 or a J1 or some other temporary basis, you are, in fact, under the law, a non-immigrant. That just simply means that your status here is temporary. The other group that we refer to in the law are immigrants or permanent residents, people who hold lawful permanent residence or green card status. And then the third group of people are citizens, so people who are either citizens by birth, because they were born in this country, or have naturalized through the U.S. naturalization process to become U.S. citizens. When we think about non-immigrants, we're going to talk first about non-immigrants' temporary status, not only because that's what you're currently holding, but that's likely where you will be headed, continue to hold non-immigrant temporary status hereafter. And so we'll spend most of our time today really talking about non-immigrant temporary paths under U.S. law. I think it's helpful for people to understand a couple of basic documents with respect to their status. Hopefully this is review. You all know that you have a passport that you presented probably to the U.S. Embassy or Consulate abroad, and then to the U.S. Port of Entry. You've probably shown that to U of I and others perhaps along the way. In addition to that, you have a visa stamp in your passport that was issued by a U.S. Embassy or Consulate abroad. Some of those interviews, you're probably still a little bit beaten and scarred from your consular interview to secure your student status. Some of you probably pursued multiple visa interviews to secure your F1 or J1, so congratulations, you made it. Although this is really just the beginning of your immigration journey, even though you felt probably a bit beaten up by our State Department during the F1 visa interview. You also have a status document, the document that's issued by the University of Illinois that controls your stay. It controls your ability to be in this country. It controls your ability to work and travel. And we have with us today Stephanie Dvorak from ISSS up here in the blue. If you don't know her and her office, something has gone awry. You certainly should know that office. And if you don't, you really should spend some time getting acquainted with that office. And we're going to refer to Stephanie and the good work of that office a few times today. So that office issues the I-20 document, or for those of you who hold J1 status, the DS-2019. That is a really critical document because it, again, controls status while you're here in the United States. It is something that you need to be familiar with, particularly with respect to employment and travel permission. And generally speaking, other than on-campus employment, you're not permitted to work. You are not permitted really to do anything unless Stephanie says it's okay, Stephanie and other people in her office. When you are here as a student, your life is controlled. We don't like to be controlled. I can appreciate that. But guess what? Your life is under some control by the University of Illinois and really by extension, by the U.S. Department of Homeland Security. The DHS has awarded the University of Illinois the authority to grant I-20s and DS-2019s, and so it's critical to the university that you continue to maintain status so that they can continue to admit foreign students in the future. The other document that's really critical is the document that you were issued upon entry into the United States, except now the CBP, Customs and Border Protection, has gone to an electronic system for the better, or so they say. And so now we're not getting white I-94 cards issued at the border anymore. I, for one, and I am not alone in this assessment for certain, am not a big fan of the electronic system. CBP has been known to make lots of mistakes, even during the paper system. So when we had I-94s issued by paper at the ports of entry, they would make mistakes from time to time. Not terribly often for foreign students, but on occasion, certainly they did. But the electronic system, in some ways you think might have been better. In fact, it's not. It's important that every time you enter the United States that you are logging into the CBP's website and confirming that the port of entry admitted you on the day you actually entered this country, in the visa classification that you actually entered this country, and that they admitted you for duration of status or whatever period of time you should have been admitted for. And I'd really like for you all to get into the habit every time you enter the United States that you're logging into that CBP online system to make sure that what you think your reality is what the electronic system of the federal government shows your reality is. Because guess what? Their reality trumps your reality. So it's really important that you understand how did they admit you, for what period of time, and in the appropriate visa classification. If you find a discrepancy, then let, I assume this is fair, ISSS know that, hey, I think they admitted me on the wrong day. One day may not be critical, but why not try to get the record corrected? And there are mechanisms in place to get the records corrected online. So bring that to their attention. That's in part what they're there for. So we're going to talk a bit about green card as well, but I really just wanted you to have some appreciation generally. And again, like I said, hopefully this is review of what documents we're talking about in connection with non-immigrant status, but also what the sort of three big areas of immigration status are here in the United States. Before we get into some of the specifics of non-immigrant visa categories, I really want to reemphasize this area of the law is strict enforcement. There are no do-overs, usually. There are no amendments that can be filed. You know, my colleagues who practice in the litigation area, well, Jen, why don't you just file an amended pleading or amended petition? We don't really do that in my world. And so it's critically important that we get things right the first time in every submission that we make to the U.S. government and the U.S. Immigration Service. By the same token, it's really important that you understand and are very familiar and comfortable with the limits on your stay. Again, you are only permitted to do and be here by virtue of whatever your particular visa status is. If you're here as a J1 research scholar, that's your universe. If you're here as an F1 foreign student, that's your universe. When you start dabbling and doing other things, you are very much putting your immediate current immigration status at risk. And for what? Because you got paid $20 for a stipend to cover something. You know, these are the things that concern me. And I always hear about them after the fact because I clean up messes. That's what I get paid to do. And if we can avoid messes, I'd really like to avoid them for you if we can. So just keep in mind the limitations of each visa class. And we'll talk about some of those limitations as we proceed. So a lot of you are here as foreign students, and I want to talk about optional practical training. This is something that is available to you generally upon graduation. It is possible to borrow against OPT time prior to graduation. And I suspect ISSS would probably say the same thing. I discourage people from borrowing against their OPT time and really saving that for post-graduation so that you have available to you upon graduation the full 12 months of optional practical training. You have to, unlike CPT, which is employment that you can pursue during the course of your study, for OPT, you have to apply for separate employment authorization. OPT will be recommended on your I-20, but it will not be the exclusive endorsement. An employer who wants to hire you based on OPT can only do so if they see your employment authorization card. The endorsement or recommendation from the university on the I-20 alone will not be sufficient to put you to work on OPT. You have to apply for the employment authorization card. Stephanie and I were talking a little bit before. One of my bigger pet peeves, honestly, is that people wait too long. Over and over and over again, I see people who are waiting entirely too long to apply for their OPT. Look, it takes 90 days. Immigration doesn't waver from that very often. On occasion, we get surprised and they start in a trend where they take 60 days. But as I mentioned, I've been doing this for like 20 years. 90 days is kind of the gig. It's 90 days. For 20 years, it has been 90 days. They rarely have deviated from that. You can apply up to 120 days in advance. So if you don't know how to apply, where to apply, and who to talk to, you really need to make yourself known to ISSS. Probably not in your first year of academic study, but at some point during the course of your study, you need to talk with them about, hey, I'm graduating at this point in time. When do you, ISSS, recommend that I apply for OPT? And again, that just really can't be emphasized enough. The other period of employment that may be available to you beyond OPT is something called a STEM extension. This is for graduates in science, technology, engineering, and math may have available to them an additional 17 months beyond the initial 12 months that literally everyone should be getting upon graduation for OPT. That 17-month STEM extension, though, is only available to you if you are working for an employer who is enrolled in E-Verify. E-Verify is an online electronic system that verifies employment eligibility for people that work for that company. Lots of employers are not in E-Verify. So if your strategy, if your personal immigration strategy is, I have 29 months available to me, I don't need to worry about applying for H-1B or some other visa class in the future, you need to be thinking about whether or not the employer who will be sponsoring you will be in E-Verify. And like I said, some are and some are not. I counsel a lot of companies about whether they should or should not be enrolled in E-Verify. And there are lots of reasons that go into whether an employer should enroll in E-Verify that are far more important to the company than being able to employ you for 17 more months beyond the initial 12-month period of OPT. So just be aware of that. The other thing to be aware of, if we're thinking about startups and new companies through OPT and STEM extensions, it is possible to work for your own company during a period of OPT or STEM. In connection with the STEM application, however, immigration might ask for an employment verification letter to confirm that you really are working for the company and that the company really is employed or registered in E-Verify. And if you're the beginning and the end of the company, who's going to sign off on that letter? You really need to be thinking about some of these things. There are far more important reasons to avoid startups, perhaps during a period of OPT. We'll get into that a little bit during the H-1B discussion, but that's a fairly immediate thing to be thinking about in connection with startups and starting companies during periods of OPT. If you are eventually seeking a change of status to H-1B, so you're in F-1 status, you're on a period of OPT or STEM, which, by the way, even during your period of OPT or STEM, your immigration status still remains F-1. You may feel like you're not F-1 anymore because you've graduated. I'm not F-1 anymore. Well, guess what? You're still F-1, even if you're on OPT or STEM extension, because that's the only visa class that there is that's available to you. OPT and STEM is work permission, but that itself is not a visa class. If you are intending to change status during a period of OPT or STEM while you hold F-1 status, then you will not be able to travel internationally during that period of time where a change of status petition is pending on your behalf. The U.S. government takes the position that if you travel during a pending change of status petition, then you have abandoned that petition. You must not want that status anymore because you left the United States. Travel generally during a period of OPT or STEM extension is permissible. However, if you need a visa stamp, if the F-1 visa stamp itself that's stamped into your passport has expired, I generally recommend foreign students not traveling during a period of OPT or STEM, because you might remember during your visa interview with the U.S. Embassy and the consular officer, the terribly friendly consular officer, no doubt, you told them that you'd be back. In connection with your F-1 visa stamping, you told them, I'm going to the United States to study, and my intention is to return. Whether you actually had to tell them that, it was certainly implied, because the F-1 stamp, J-1 stamp, and lots of other visa categories truly are a non-immigrant temporary visa category, and whether you said those words out loud or not, that was implied. So you graduate, you're on OPT or STEM OPT, and you want to travel and you need a new visa stamp. Guess what? The very first question is going to be from the consular officer. Are you coming back now? You've graduated, you found a job in the U.S., what's your plan after the OPT or STEM? Are you coming back to your home country still? And if you say no, or you hedge, or you waver on that, they're probably going to deny your F-1 visa stamp. So the way to avoid that is don't travel during a period of OPT or STEM. If you have a valid F-1 stamp during OPT or STEM, then it's probably fine to travel. You'll need evidence to present to the port of entry that you're on OPT, so your employment authorization card, probably a letter from the employer that's employing you during OPT or STEM. But travel then, when you have a valid F-1 stamp, is not all that big of a deal. I should mention, too, that periods of unemployment are taken pretty seriously these days by the U.S. Immigration Service. So the rules generally are that you cannot have a period of unemployment of anything more than 90 days. The U.S. government understands it may take you some time to find a job, but you can't have unemployment of 90 days, and during your STEM extension, that period of employment limitation goes up to 120 days. One other thing about self-employment during a period of OPT that I'll mention is the degree issue. So all OPT, whether you're working for a private employer or your own startup, OPT is only authorized if you are working in a field or in a profession where your degree, discipline is relevant to that occupation. So I get questions from time to time from employers who want to know, can I put this person to work on OPT? They have an employment authorization card. And of course, my questions will be, what is their degree in, and what is the job that you propose for them to do? Performing janitorial services with a degree in business administration probably isn't going to cut it. I understand that you were trying to avoid a period of unemployment, and maybe no job, or maybe a janitorial services job is better than no job, but that is not relevant, and so it's not authorized employment. I'm literally not making up that example, by the way. That's real. So it's important that you keep in mind the relevance of the degree. The other thing, like I said, is what the options will be post OPT and STEM extension for those of you that will qualify for a STEM extension. So I want to talk a little bit about a couple of the visa options. I have saved H-1B for last because it's the most commonly used and it's the one that takes the most time. I'll give you a little teaser though. There are significant flaws in the H-1B system. I'll give you two right off the bat to help you pay a little more attention to these slides and why it is that I'm leading with these slides, because the H-1B system has at least two. There are more. I'm going to give you two significant flaws so that you'll pay attention during these earlier slides, because these are given to you for a reason. So the first major flaw with H-1B is that there's an annual quota. This past year, we filed H-1B petitions starting April 1 for fiscal year 2015, which was to begin, or is going to begin, October 1st of 2014. The limit on the number of H-1B visa petitions is 85,000. The US government received 172,500. So a lottery was instituted and has been every year for the last several years. The odds aren't great. They are getting worse. Next year, what will happen, because by the way, the people who applied this year and didn't make it, they didn't go home. They're just competing against you next year. So it won't be 172, it'll be 232. I'm making that I am making up. But my prediction is, because this is what's happened over the last several years, is that each year it gets exponentially worse. So that's the first major drawback that applies to everyone seeking H-1B status for the first time. The other major flaw is with respect to startups. For all the discussion by the administration for the importance of foreign investment in this country, entrepreneurship in this country, and for just job creation generally in this country, there are no clear paths for foreign students and entrepreneurs to pursue non-immigrant temporary status in this country and then eventually green card. H-1B is no exception. It is not your magic bullet to remaining in the US beyond foreign student status. One chief problem in the H-1B category with respect to startups and entrepreneurship is that you have to be able to demonstrate a sufficient employer-employee relationship. And if you're it, then who's the employee and who is the employer? We can't tell the difference. And so H-1Bs get denied over and over again on that control issue and the sufficiency of an employer-employee relationship. We're going to talk more about that in a minute. But for those reasons, those two reasons in particular, I want you to be generally aware of the other non-immigrant visa categories that are available to you. And this is why it's so important, because H-1B is not going to do it for some of you. Now, some of these aren't going to be available to you either, unfortunately, because they're just not going to apply to your circumstances. But I just want you to be aware of some other options. So one of the other major categories under U.S. immigration law is something referred to as L1. So L1 is for intra-company transfers. This is available for foreign nationals who have worked for a minimum of 1 year abroad in the last 3 years and now are seeking entry to the United States. in either a specialized knowledge capacity or executive or managerial capacity. So you say, well, that's great, but I'm here now. I'm not working abroad. And by the time I'm ready, by the time I graduate and ready to pursue an L1 status, it will have been more than 3 years, let's say. So even if I worked for a company abroad before I came, then 3 years will have gone by and I'm not going to qualify. The reason I mentioned this to you, though, is that some of you will decide to start your companies abroad. Some of you will work for small, medium, large companies abroad upon graduation because you will miss the H-1B quota. The numbers aren't great, as I mentioned before, so some of you will end up abroad. And some of you will end up working for companies, multinational companies abroad. And so for those of you who might do that, in fact, literally on my way here this morning, I had a conversation with one of my clients who is thinking about hiring somebody back to the United States. This guy had previously held H-1B, went back home to India for a couple of years, and now he wants to come back to the US. Well, he works for the company abroad, my client's company abroad in India, and we're now abandoning prior H-1B status. We're not even thinking about H-1B status for him any longer. We're actually going to bring him back probably under the L1 category. So a 1-year period of time is not all that significant. But what you do have to establish is that you have acquired some level of specialized knowledge, or that you're employed in a managerial or executive capacity abroad, and that that experience is somehow meaningful to the US company that's seeking to sponsor you now. The challenges that we're having right now in the L1 category, particularly because the H-1B numbers have not been sufficient, there is no quota for L1. Immigration knows that there are no quotas for L1, and so they're really hitting us pretty hard on whether people have sufficient specialized knowledge or not, whether or not they really are managers or not. There's a provision in the law that talks about even if you're a manager without direct reports, but you are responsible for an essential function of the company, you may be able to qualify as a manager. Immigration's really challenging us on those functional managers. They are questioning the essentiality of that function within the company, and so we're getting a lot of pushback, and have been for probably 5 years or more, on whether people have sufficient specialized knowledge or really are responsible for an essential function. For those of you who have decided to start up your company abroad and not in the United States, and then after you establish it for at least 1 year, hopefully a couple, because we really don't like it when people just apply on the 366th day after they've started employment abroad. So hopefully a little while longer abroad. And then we want to start a U.S. branch or a U.S. subsidiary, and then be sponsored by the new U.S. subsidiary under L1. Immigration has some special rules associated with the establishment of new offices. So the burden goes up a little bit. Instead of getting a 3-year approval on the L1, which is customary, new offices will only get a 1-year approval to evaluate the company again at the conclusion of the initial 1 year. We have to also establish that the company abroad is going to survive your transfer to the United States. So you set up the company abroad, you work for it for at least a year or more, you set up a U.S. subsidiary, you transfer to the U.S. subsidiary. If the foreign company is going to collapse without your presence, L1's not going to work either. Immigration's looking for that. We're not looking for a shell game here. We have to have somebody in place that's going to run the company abroad if you come here to run new U.S. operations. I will say, though, that L1 is a great transition to green card. There are a couple of really nice ways to transition to green card under the L1 category, and it's specifically called for in the statute and the regulations that you have a way to emigrate. If you come in under the L1 category, you can immigrate to green card specifically. The maximum period of stay associated with the L1 category is 5 years for specialized knowledge worker and 7 years for managers and executives. This next category is, and these letters, by the way, just come from the order and the statute. So there's not necessarily a rhyme or reason, but these are the visa classes that are known by statute. So the e-visa category is for traders and investors, but it's only available for people who come from countries with whom we have an international, at least bilateral treaty with. So lots of countries are on those lists that qualify for E1 and E2 status, but notably, India, mainland China, Russia, and Brazil, all pretty significant countries in the world economy, do not qualify for E1 or E2 status, unfortunately. So you have my permission to nod off during this phase if you're from one of those countries, because they just don't qualify, unfortunately, for E status. Self-employment is permitted under the E category, which is helpful. There is no obvious path to transition to green card. However, there's no maximum period of stay associated with the E-visa category. So no maximum period of stay. I can hold E status over and over and over again, but it may be challenging for me to transition to green card. Now, that doesn't mean you just come in and hang out forever in E status. You have set periods of time that you're authorized. So visa stamping for e-visa holders is limited to 5 years. Each entry that you make into the United States is only valid for 2 years. So every couple of years, too, you are either filing a renewal petition with the U.S. Immigration Service, or you are traveling outside of the country and being readmitted for a new 2-year period of time. But at least your visa stamp that's in your passport is valid for 5 years, so you only have to go see those people every 5 years. So a little tricky, very unique category, but something to know about. It is only available for people who share the same nationality as the company. So you start up a company and you're from Germany, let's say. You start up a new company in the United States and you're German. You can then not only establish an E1 or E2 for yourself as the principal investor, but you also then can hire however many German citizens you want and need, as long as they otherwise meet the criteria for e-visa classification. So we see e-visa utilized by very, very large multinational corporations. Japanese auto parts manufacturers are a huge fan and advocate for the e-visa category. So companies that are foreign-owned use this category to immigrate people from their own countries under this visa path. You have to be able to establish that if it's for E2 investment, that the funds are at risk and that you have made a substantial investment relative to the general scale of the enterprise. And the scope of the enterprise has to have capacity beyond providing a standard of living for you and your immediate family. So it has to be beyond just you. We have done e-visas for people who have owned franchises, donut shop, other entrepreneurs. The donut shop's a little tricky. We're probably never going to get a green card for that guy. But he's held e-status for a really, really long time, and he employs his spouse and his children. And he must also then employ some other people at the donut shop. I don't know how many people you need to run a donut shop, but apparently more than a couple. See if there's anything else I want to talk to you about on ease. I think that is it. Okay, 01. This is a category uniquely that's available for aliens of extraordinary ability. Lots of people think they're extraordinary. A smaller number of them actually are extraordinary. But you can't be modest and shy. Either you got it or you don't. And if you can't advocate for yourself to me, then I can't advocate very well on your behalf. So part of my interview when I'm thinking about 01 for people is, did you convince me even a little? Because I'm pretty good at pulling stuff out of you, but if I'm carrying all this burden and weight and you've got nothing, then I'm not all that motivated to help you. So this is not for the faint of heart, but the approval rating on O1s is remarkably high. Now, there's a path that's very similar to O1 on the green card side of the equation. Approval ratings on that EB1 category for green card sponsorship is not as great. But O1s, I think the approval rate is somewhere in the 80%, 80 to 90%, which is remarkably good. But you have to meet the criteria. This is the criteria. So either you have you meet 3 of those criteria, or you don't. There's a lot, like I said, advocacy that goes into this to help establish that you met at least 3 of those criteria. But at the end of the day, you either have it or you don't. And again, like I say, a lot of that is up to us to help establish that you have it. This is a really great temporary visa category that some of us need to be thinking about probably a little more than we are. By the way, you can't self-petition in this category. You have to have a sponsor. It's possible that you could have an agent sponsor. So I live in Indianapolis. I do lots of work in motorsports. We use the O1 category a lot for race car drivers. They almost always have an agent sponsor on their behalf, and it works really nicely. I don't know that I've done that necessarily in the traditional business context, but it's something I'd certainly entertain. So unlike the EB1 equivalent for green card where you can self-petition, but this one you can't on this temporary side. The other category for you to be aware of is very country specific. We have certain free trade agreements with countries around the world. Some of those free trade agreements have carved out specific and unique visa categories. This is pretty much it. Under our NAFTA agreement, we have visa categories that are devoted to Canadians and Mexicans. That category is a little bit unique because there's a list of occupations that qualify for this TN visa category under NAFTA, and either you're on the list or you're not. Either your job is on the list or it's not. I'm working right now with a company who we're trying to get a controls engineer in, but he doesn't meet the degree requirement for an engineer, so we're going to try. There's a scientific technologist category, and even though he's paid $95,000, I'm trying to figure out a way to define him as being in a support role, supporting the project engineer or the chief engineer, because that's all that works for me under TN. We don't have time to wait for H-1B next year, so TN is interesting. It's great for Canadians and Mexicans, but it definitely has its limitations. The E3 category is for Australians, and then there's an H-1B1 category for Singapore and Chile. Both of those last 2 categories function very much like the H-1B category. There are annual quotas, but we typically are not hitting those quotas. So that brings me to my favorite. This is really the bread and butter of our practice. We do H-1Bs all the time. Even when there are no H-1Bs to be had, we're still doing H-1Bs. And the reason why we do H-1Bs year-round is because every time someone changes jobs or changes employers or needs to extend their stay, we have to file a new H-1B petition subject to all of the hoop jumping that we had to endure on the initial H-1B petition. I have never actually figured out how many H-1B petitions we file on an annual basis, but we file a lot. This is the most common and prevalent visa category, followed probably not too far by the L1 category. So L1 or H-1B is for specialty occupations. And what immigration really means, what Congress really meant when they passed the H-1B statute to allow foreign professionals to come in, is that it's not just for any job necessarily. I will say it is for most professional occupations, but the catch for H-1B on just a basic definition, from a basic definition standpoint, is that the H-1B position has to require a degree in a particular discipline. And so when I talk to foreign students, especially at the undergrad level, and they tell me that they're studying business, I say, change your major. Because if you go out and look for work, chances are, if you want to be sponsored for H-1B, putting aside lottery and lots of other problems with the H-1B category, chances are a position that will accept as its minimum a business degree, an undergraduate degree in business, probably will accept lots of other kinds of degrees too. So H-1B is great, but you have to keep in mind that it is a specialty occupation, and that means the position has to require, and you must meet the minimum degree requirement, and it has to be in a specific discipline. So chemical engineering, requiring a chemical engineering degree, and you have a chemical engineering degree, fantastic. Other positions that are broader than that, right now, in the last 5 years, we have done a ton of work for lots of different types of companies that have regulatory affairs specialists. These are people who sit around and figure out worldwide regulatory schemes so that they can get their products through various international markets. And companies really value those positions, but many of them fall into this trap where for a regulatory affairs position, they will accept a degree in English, because you have to write pretty well, a degree in business, because that's just a good, well-rounded discipline. They'll take law degrees. And so if I see a job description where we've got lots of degrees required or potentially eligible or available for that, to qualify for that occupation, I start to get a little twitchy about whether or not we're going to meet the requirement for H-1B sponsorship or not. So business majors, change your degree. The other component to H-1B is a prevailing wage requirement. And that's an issue for all employers of all sizes. It's required. The larger the company, I suppose, maybe the greater assurance that they're probably going to meet the prevailing wage, but not necessarily. I have conversations with companies of all sizes and all locations around the country where we have to talk about prevailing wage and potentially raise salaries for the sponsored H-1B worker if we're not meeting the prevailing rate of pay. I particularly worry about prevailing wage and H-1B sponsorship for smaller companies. I have a client right now in California, a startup that makes me miserable on a pretty regular basis because they fairly consistently have allowed the employee's wage to dip below the prevailing wage, or they just don't pay him. They also don't offer him health insurance. And why this guy continues to stay there, I don't know. Either he believes deeply in the mission or he's really not very good at his work and he can't find anything else better to do. I don't know. I don't know which it is. But it is tricky if we have prevailing wage problems. Prevailing wages are job and location specific. So the prevailing wage for this company in California is going to be very different than the prevailing wage for a similarly sized and situated company in central Illinois. So keep that in mind. I mentioned before the control issue and the employer-employee relationship. What immigration really wants to know is who is in control. If you, during a period of OPT or STEM extension, incorporated the company, were identified as the original founder, and I told you, and ISSS told you, you can do that during OPT, that may totally shoot you in the foot when it comes time to doing H-1B sponsorship, because we are not able now to sufficiently distinguish between you and the company. If you are the sole owner, 100% stock owner of the company, you can name a board of directors that is separate and distinct from you, but immigration probably isn't going to believe that even if you say they can fire you, that's probably not actually true. And immigration's going to see through that, which is really frustrating because this control issue, hitting this employer-employee issue hard, has only really been coming about in the last 4 years. In 2010, there was a memo that immigration pushed out on this control issue, on the sufficiency of employer-employee relationship issue. And guess what? You were not their target. You were simply the collateral damage. Their target, when they devoted so much time and energy and resources and drafted this multi-page memo talking about the importance of employer-employee relationships and the distinction between those two things and who has control, they were very interested in staffing companies. Immigration is convinced that fraud is pervasive in the H-1B visa scheme, and in L-1, by the way. And so they drafted this memo that talks about you really need to be able to distinguish between who the actual employer is and who the employee is. And when we had IT staffing companies, and continue to have IT staffing companies, and they're placed, H-1B workers are placed at client sites, immigration's argument over and over again is the client is actually the employer, not you, staffing company. And client is simply using you to pursue H-1B so they don't have to incur the expense and the responsibility of employing H-1B workers. And so that was really their objective. But in the course of hitting that issue so hard, they really made it increasingly difficult. This has always been challenging to do H-1Bs for startups and entrepreneurs, but after that memo, it's become increasingly difficult. The other disconnect that we have going on is that we have, I'm afraid, a whole lot of lip service occurring at the administration level and high-level people at the Department of Homeland Security, but then when we get down to the agency level, where people are actually adjudicating our H-1B petitions, they're not drinking the same Kool-Aid. They don't believe in the value of startups. They're still very much concerned about visa fraud. And so we have a little bit of disconnect even within the agency. So it is possible for, you cannot be self-employed, but if we could have a minority or even majority shareholder that someone other than you as the sponsored H-1B applicant, and give them control, even if we don't give them ownership, and we set up a separate and distinct board of directors, there may be a way to make an H-1B work. But that comes with some very significant challenges. It requires you to be thinking about H-1B and the limitations of H-1B during perhaps OPT and STEM before you incorporate the company. So it's really important to be thinking about those things. The other issue is even if you're able to establish the control issue and the employer-employee relationship issue, the size of the employer is going to haunt you, I'm afraid. And we see this in circumstances where the H-1B worker has absolutely no ownership or control of the H-1B petitioner. But if the size of the company is under 5, under 10 employees, then immigration is going to ask a lot of questions about, is this really a legitimate enterprise or not? Is it sustainable? Are they going to meet the prevailing wage requirements? Which, by the way, is this client that's in California. The H-1B applicant himself has no ownership interest in the company whatsoever. He's just suffering from the size of the employer, and because, as immigration would have suspected, they're having funding trouble and they're falling below prevailing wage. So some of the things that immigration will ask about in connection with employer size is corporate records, payroll, show us payroll for everyone over the last year or 2 or 3, pictures of the facility, a lease agreement if you have a physical structure, community letters from people in the community that know about your work and care about your work, granting documents, bios on board members, bank statements, those kinds of things. So let's see, did I hit all of those? We talked before about generally visa categories being employer, job, and location specific. Same holds true for H-1B, and it is very, very strictly interpreted. One other thing I'll mention, these are not all of the non-immigrant temporary visa categories. There are countless others for athletes, for religious workers, for other kind of unique categories. I just wanted to give you the broader categories that you're more likely to run into. So I mentioned before the annual H-1B quota, and this is just a little bit of history to show you how long and pervasive this issue has been. So I mentioned before that, that H-1B sponsorship, the fiscal year runs October 1 to September 30th. And so right now we are in wrapping up fiscal year 2014. So for fiscal year 2015, we made filings on April 1 for employment to begin in a couple of days. So I have a lot of very happy people who are getting ready to start their initial day of H-1B employment on October 1st. I also have an equal number of very unhappy people who are still on OPT or STEM or have returned home or have married their U.S. citizen girlfriend, which is fantastic. We'll talk about that in a minute. And are not going to pursue H-1B. Hopefully the people that married their fiancés are happy nonetheless, even if they don't have H-1B anymore, available to them anymore. So you can see we've got a long history of just insufficient H-1B visa numbers. It's gone back now for several years. The quota actually goes back much farther than this. There was a really nice period of time in the late 2000s where the number was actually sufficient. So Congress had raised the annual quota from 65, it's been 65,000 for a really long time. They raised it because they appreciated the tech boom and that we had a lot of people that we needed to bring in. And then that sunset in 2009, and so numbers were not sufficient anymore. So when the market has been able to drive visa number availability, it's been great. When we have put artificial limits on the number of H-1Bs we can bring in each year, it's been a disaster. And so what this means right now, for instance, is I don't have H-1B visas available to me, and I haven't since April, and they won't be available for me to use or anyone to use again until next October. So I have 18 months of a dry period where we cannot pursue new H-1B visa petitions. So I'm now thinking about, I already have a whole lot of people on my list from last year who didn't make it. They're on my list for fiscal year 2016, which starts October 1 of 2015, because in January of 2015, I'll start preparing 2016 H-1B petitions so that I can file those on April 1st of 2015. If you are graduating in May, any May of any year, unless and until Congress raises the annual quota, I can safely say this is good strategy. You should be thinking about filing for an H-1B petition, perhaps even before you graduate from a master's or higher program. Because I can file April 1st, you don't graduate until May, you have to meet the degree requirement for the offered position at the time of filing. So if you're graduating from an undergraduate program in May, then you can't apply in April unless you have a different undergraduate degree that's relevant to the offered position. But if you're graduating in May from a master's program and you also happen to have a relevant undergraduate degree, then I probably will be encouraging you to file in April, not based on the master's degree you don't have yet, but based on the relevant undergraduate degree. But that requires a great deal of active and early planning, not only on your part, but principally on your prospective employer's part. And so what that means is, hopefully you're having really good CPT experiences during the summer, and all of this can be contemplated perhaps a year in advance. If you're thinking about OPT and H-1B sponsorship for the first time during your OPT, that may be okay, but you're eliminating a filing opportunity that might have been available to you earlier. So if you graduate in May and then you're thinking about you have a year, that's plenty of time. Well, by May, you've already missed the most recent H-1B quota. Now you've got to be thinking about next April, but that's your one and only shot. Maybe, unless you qualify for STEM, then you get 2 more shots during your 17 months of STEM extension. So it makes it really difficult. But if you're not the one advocating for yourself with your employer, then you're relying on your employer to call somebody like me that says, hey, how much do you like that gal that's working for you? Because let's think about H-1B strategy. I do that with my clients every single time. I talk to them about their foreign student population as soon as I become aware of their foreign student population. But there's 2 things I can't control. They're not all going to use me. Not all lawyers are going to advocate for foreign student sponsorship as much and as early and as often as I do. And some employers don't get it. They just don't get it. They don't know. Now, a lot of my clients who have come to me to talk to me about this, they don't really get it either. But I've pounded on my desk enough about it that they know, wait, we hired a foreign national. I think I have to call Jenifer. What are we supposed to do? Should I be talking to you about this person now? Almost never would I say, no, it's too early. Nearly every single time that an employer talks to me about, hey, we have this foreign student, he or she's just working for us on a part-time basis now, but we really want to come up with kind of long-term strategy. He or she said that they have OPT and STEM available, so I don't think we need to worry about this right now. I'll say, when do they graduate? Send me their name. I'm putting them on my H-1B list for the next available filing opportunity. Because with the quota situation the way it is, you may need 3 shots at it. We have people who have applied for H-1B every single year for 3 and 4 years and still have not been lucky enough to get H-1B. Now, at that point, I start to think that the universe is trying to communicate to them and they're not paying attention. But the point is, you can apply, but let's improve your odds by applying as early as you possibly can. So there are some exemptions from the H-1B quota. So institutions of higher education, the University of Illinois certainly is exempt for people that they hire. So you have to be an employee of the university. Then you don't have to worry about H-1B sponsorship, which is fantastic for them. But frankly, it's fantastic for the rest of us, because if they were taking our numbers, we'd be in worse shape than we already are. So in addition to institutions of higher ed, nonprofits who are affiliated with institutions of higher ed also are exempt. That affiliated word is in quotations because immigration's trying to poke at that a little bit. They're questioning the sufficiency of affiliations between nonprofits and institutions of higher ed. So hospitals are pretty consistent users of this cap exemption. But some hospitals, A, are not nonprofit, and B, some of them, a lot of them, do not have a sufficient affiliation with an institution of higher ed. Other nonprofit research organizations are exempt from the quota. Doctors who are in medical residency and hold J-1 visa status are exempt. And if you've already had H-1B status, so you've already been counted, and all you're doing now is switching employers or filing an extension of stay, then you are not counted again. Once you've been counted, you won't be counted a second time. However, if your H-1B, initial H-1B was with a cap-exempt organization and you are now moving to a cap-subject organization, you will be counted when you move, in connection with that move to a cap-subject. I mention here that there are, in addition to the 65,000 H-1B visas that are available, there is a special set-aside of an additional 20,000 H-1B visas for graduates of U.S. master's and higher institutions or programs. So for those people, they really get each year 2 bites at the apple. They apply one petition, H-1B petition, to U.S. immigration. We identify it as a master's cap petition. Immigration first considers that master's cap petition against the 20,000 master's quota. If they don't get one of the 20,000, and a lot of them don't, then they roll over to the regular category for this that's allotted for where 65,000 are allotted. So those people get kind of 2 shots at it. But even still, we have lots of people who have missed both of those quotas multiple years in a row. I already talked about small employers, so I won't hit that again. It's important to know that there is a component of export compliance that goes in, not just H-1B, it actually applies to L-1 and some other visa categories as well. What I'm talking about here is that you probably are generally familiar that the U.S. Will not conduct trade with certain countries. It would be illegal for you in the U.S. to ship goods to certain countries that the U.S. doesn't want us to ship stuff to. The same thing applies when U.S. companies hire foreign nationals from certain countries. The knowledge that is transferred between the U.S. company and the foreign national may also be restricted. There may be a license that has to be secured. And the countries and the type of knowledge, there are some surprises in there. So it's not simply a matter of, well, if you're Canadian, you never have to worry about export compliance. That's not quite true. There are certain technologies and other knowledge that we will restrict, even for people from Canada and Western Europe. H-1B visas have been subject to site visits. This is a relatively new phenomenon in the last few years. They have hired retired immigration agents to come and visit H-1B employers to make sure you, as the H-1B employee, really are working where the employer said you would work, that you're really getting paid the way they said that you would be getting paid, and that you're really doing the work that you said or that the employer said that you would be doing. I mentioned before the importance of amending petitions if there are changes in employment. Employers, unfortunately, don't always take that as seriously as they should, so you need to know that. If you're holding H-1B status and there's a change in your employment, then you need to make human resources aware of that, because sometimes they're the last to know, and that's usually who's controlling the immigration work. It's important for you to be maintaining proper status. Same thing that I said before. When you're in H-1B status, you're only authorized to work for that employer. You're not allowed to do work on the side on a part-time basis for your company that you're starting. And you can tell me, well, yeah, but it's not really going anywhere yet. Okay, maybe we need to then have a conversation about what is in development and what is actual work activity. And I might agree with you, but I might not agree with you that it's not work activity. So it just kind of depends on what the particular facts are. So it's really important that if you are engaging in any activity beyond the actual work that you were doing for your H-1B employer, that you talk to a qualified immigration attorney to make sure that you're permitted to do that side activity. So H-1B is subject to a 6-year limit on stay. Extensions, limited extensions, are available beyond that normal 6-year limit, but both of them consist of extensions that are only available if you've timely initiated the green card process. So we're going to talk about green card in a minute, but just know that 6 years is it for H-1B unless you are pursuing green card. Then you might qualify for additional time beyond this 6-year limit. If you're terminated from H-1B sponsorship, the U.S. employer is required to pay your return transportation home. Only you, not your family, only you, not all your stuff, and a one-way coach class, not first class, ticket to your home country. I get that question all the time. I go, no, I don't fly first class. We're not sending people back first class. They also will be obligated to withdraw your H-1B status with the U.S. Immigration Service, and they need to do that timely. So I wanted to perhaps try to demystify paths to permanent residency or green card status a little bit if I could. Sometimes people think that there's lots of ways to get a green card. There really aren't. I mean, this is pretty much the exhaustive list on ways to immigrate on a permanent, long-term basis to the United States. So the first we'll talk about in a little more detail in a minute, but it is available, a path that's referred to as labor certification, which is a labor market test to prove that there are no, not even one, U.S. workers available and qualified to do your job, the job that you're doing as the sponsored foreign national. So a very high standard. The Department of Labor is very, very strict about labor certification. So when we can avoid it, we certainly do. But almost everyone who pursues green card based on an offer of employment goes through labor certification. So we're going to talk about that in a minute. There are a lucky few who are exempt from labor certification, and that's that EB1 category I referred to before, those O1 equivalents. We'll talk a little bit more in depth about those handful of people that are exempt from labor certification. You may have heard that you also can make a substantial investment in the U.S. economy and be awarded green card. And by substantial, they actually have a dollar figure, unlike that E category on the temporary side, where the dollar figure is not provided. It just has to be substantial relative to the enterprise. For this green card path, there's a very specific dollar figure. You have to invest $1 million in the U.S. economy and employ 10 U.S. workers, or if you're investing in a rural area or a targeted employment area, you can invest $500,000, but you still have to employ 10 U.S. workers. I talked to a lot of people about this EB5 category, and almost all of them don't go anywhere. A lot of people are excited about it. A lot of people think that they can do it. Either people have the cash, but the nature of the investment is not going to result in creation of 10 U.S. jobs. So buying up a bunch of real estate is probably not going to do it, because most real estate companies, property management companies, right out of the gate, you're not going to need 10 U.S. workers. So we have a lot of conversations about it, but man, they just don't go anywhere. Most of them don't go anywhere. The other way, which I will strongly encourage you to think about, is the diversity lottery. So this is literally a lottery system. It is becoming available basically now. We just wrote an article on our website about the lottery. The State Department has not even published the next round of lottery guidelines yet, but it literally should be coming out any day now. But it is truly a lottery. You can't win if you don't play. It is available only for certain foreign countries, however. So because it's a diversity lottery. So Western Europe is not on the list of applicants that are eligible for the diversity lottery. Japan, Canada, India, definitely not eligible, but there are lots and lots of countries that are certainly on the list. Mainland China, definitely not. But there are a lot of countries that are. There are very specific rules associated with the lottery. You have to literally hit every mark on the lottery application, or they will just dump your application and move on to the next one. But a great system. It doesn't cost very much. If you follow instructions even pretty well, it's not that hard. But it is a lengthy process. It takes a couple of years to make your way through the process, but something to consider if your country's on the list. The other way that a whole lot of people immigrate to this country is based on a family relationship. But this is immediate family. So parents sponsoring kids, kids sponsoring parents, husbands and wives sponsoring each other. Siblings technically are on the list, but you got to be outrageously patient to the tune of about 10 or 20 years. But a lot of people immigrate based on an immediate relative relationship. So I was teasing earlier about the fiancés, but the reality is some of you will marry Americans, and this is the way some of you will, in fact, immigrate. If I have, and this has come up over and over again, I have a lot of corporate clients, and we'll be in the labor certification process. Maybe it's going well, maybe it's not going well, and then we'll find out, lo and behold, the foreign national's dating and has just gotten engaged to an American, and we stop, literally, the green card work based on employment sponsorship because pursuing green card based on marriage to a U.S. citizen is exponentially faster, easier, and cheaper than the green card sponsorship that we were doing anyway. In fact, I often will convince the company to hire me to do that work instead. So the couple gets the benefit of having a lawyer that they don't even have to pay for to do the family-sponsored work, and the company's still coming out way ahead because we were going to sponsor you for green card anyway. Now we're just doing it faster and cheaper. Asylum is certainly a viable way for some people to immigrate to the U.S. on a permanent basis and secure a green card. It's really important to know, however, that you can't just come from a rotten part of the world. You just can't be from a place where you're currently making the nightly news from your part of the world. You have to be able to demonstrate individual persecution, and that is a really tough standard. It's a very unpredictable standard, and what I like to tell people is people who do really bad things to you tend not to leave a paper trail. So the evidence, creating the evidence and documentation that you were individually persecuted sometimes can be quite difficult. The last way I would not recommend, this is for people who are literally in removal proceedings before an immigration judge, their last leg before they're thrown out on their ear and formally deported from this country. You actually can seek a cancellation of that removal if you can establish that you have been physically present in the U.S. for at least 10 years and that you've been a good citizen, despite the fact that obviously your immigration story has gone very bad. So not what I would recommend, but certainly on the list. So labor certification, I mentioned before, this is the way most of you, at least if you're pursuing green card based on an employer sponsorship, will secure green card, is through a labor market test. There are 6 discrete pieces of recruitment that are required as a part of a sufficient labor market test. If H-1B is the bread and butter on the non-immigrant side, this is the bread and butter on the green card side. We do lots of green cards, and in fact, when I first started working for that immigration boutique firm, this is all I did. All day, every day, only labor certifications. That was my universe. It was sad. I was 22 years old, and that was my life. Was putting ads in the paper, trying to establish that we have sufficiently conducted a labor market to prove that there are no U.S. workers qualified and available. So I've been on your side for a really, really long time. The Department of Labor takes this very seriously. Their role in the U.S. federal government is to protect the U.S. labor market. So the policy behind all of this is that U.S. companies can sponsor foreign nationals on a short-term, temporary basis, but when we think about employing them beyond the limits of their short-term visa stay, so beyond 5 years or 6 years or whatever the temporary status allows, then the U.S. government says, hold on, what about our U.S. workforce? How come U.S. workforce isn't being considered? Why, U.S. company, do you really have to have a foreign national in this job? And this gets tricky because usually on labor certification, most companies' policies is you have to work for them for at least a year, maybe longer, before they'll initiate green card sponsorship for you. And so you're already in the job, you've been in the job, presumably you're well liked, which is why they've decided to keep you beyond what they know is the 6-year limit. And now we're having to put ads in the paper to recruit again for your job, and fingers crossed that we don't find anybody that's qualified to do the work. So if there had been layoffs with the company, that may be a factor that's affecting our success on green card. Just unemployment rates in general have definitely skewed the Department of Labor's opinion about labor certification, particularly in places like California and in New York, where they are convinced that there still are sufficient U.S. workers qualified and available. And so we frankly just have a harder time in certain jurisdictions than we do in others on labor certification. The labor certification, once it's filed, is valid for 180 days. Then you can move on to the second step of green card sponsorship. But it is a rigorous, technical, and very strategic part of the green card sponsorship is to sufficiently make your way through a labor certification. One thing to keep in mind for startups and entrepreneurs, you can't, just like we have problems on the H-1B side, I would say we even have greater problems on the green card side, on labor certification at least. There is a specific question, which is what I've shared with you here, that's on the labor certification application that requires us to make an attestation under penalty of perjury about whether you or any member of your family has an ownership interest in the company or any other sort of relationship that would be of interest to the U.S. government. The reason why immigration, and specifically the Department of Labor in this instance, are so interested in this is that, again, they're in this game to protect the U.S. labor market. And if you are controlling the company, then you are probably controlling the labor certification, and you are probably unduly influencing both the recruitment of U.S. workers and the evaluation of those U.S. workers. And so the Department of Labor's response, if you say yes to this question, will be, this position is not a bona fide job opportunity that truly is available to U.S. workers because you're the only one the company wants because it's your company, or it's your dad's company, or you are too close to the company. You're influencing and controlling the company. I represent in a company in Chicago that is a very large, prominent, you know this company, plumbing fixture company. It is Taiwanese owned. It is a large multinational corporation, and they have a guy who works in the marketing department. Well, his dad happens to be the CEO of the entire company. But this guy couldn't be doing more run-of-the-mill, junior level, entry level work in the marketing department. I couldn't think of a lower level job that's still professional that would qualify for H-1B and be pursuing green card at the same time. And we had to mark yes to this question because he does have a small ownership interest in the company, and his dad owns the company, founded the company, it's his company. And I feel like we put together a fantastic response to the inevitable audit that we got because we answered this question yes. And I'd say at this moment, maybe I'm feeling a little down today, it's like 50-50. I really don't know whether or not it's going to go through. This guy isn't influencing anything from the marketing department. He's just not. He was hired by the president and HR department of the U.S. company that is a separately owned company, but ultimately owned by the foreign parent. And because we had to answer yes to this question, I'm concerned about whether or not it's going to go through. So if we're having trouble, and I don't know, it's going to be probably 4, 5, 6 more months before we get an answer from the Department of Labor on that case. My point is, if I'm that hung up about that fact pattern, I'm really, really hung up on other fact patterns. So for startups and where there's just not enough distinction between the company and the sponsored foreign national labor certification, we probably need to be looking for a different way to immigrate people beyond labor certification. So the next step of the green card process, I'm not going to talk a lot about this, but once you secure labor certification, then you move on to the next phase of green card. These are kind of the things that need to be included. I really want to talk about labor-cert-exempt now that I've painted a very grim picture of labor certification for self-employed people and for founders and those with an ownership interest. So these are people who are exempt from the rigors of labor certification. There are a group of people that we refer to as priority workers. They are exempt from labor cert, and then there's also some national interest waiver applicants that are available. So multinational managers or executives, those are those L1As that I mentioned before, the visa category where you work for a company abroad and then you immigrate to the US after 1 year of employment abroad. If you're a manager and executive in that category, this is probably the way you're going to immigrate for green card purposes as well. For for outstanding researchers or professors, these are people that are typically employed by universities, but not always. I represent lots of private companies where we've made use of the outstanding researcher option that is available and worked very well. There's a list of about 6 criteria. You have to meet at least 2 of those criteria to qualify for outstanding researcher or professor, and the criteria includes things like awards, publications about your work, you've judged the work of others, you have contributed in some particular way to original work, you have authored journals and other kinds of things that are of some major significance. Extraordinary ability is another way that people can immigrate through EB-1 as a priority worker. That is the category where I mentioned you can self-petition. There's a list of about 8 or 10 criteria as well. You have to meet at least 3 of those. They're very similar to, not identical, but very similar to what I rattled through on outstanding researchers and professors. The other way that you might be exempt from labor certification is through something called national interest waiver. And these petitions also can be self-petitioned, which is nice, but you have to be contributing work that will be, that is substantially, has some intrinsic merit. So there's something significant about the work itself that is of value and of interest nationally. The work also has to be national in scope. And some work doesn't, lends itself to that better than other types of work. But I think that that's just something that has to be explored depending on the nature of the work. And then there's a third component to national interest waiver where we have to establish that labor certification shouldn't be required. And it shouldn't be required because your value as the applicant exceeds the value of protecting the U.S. labor market. So whatever contribution you're making really outweighs the significance and the value of the labor market testing. I think we've covered EB-5 pretty well. The main hiccup, as I mentioned, it's either the dollars or the U.S. workers. The other major issue in connection with EB-5 is tracing the funds. Some countries allow for transfer of funds in a way that's very different from what the U.S. permits, and it gets really complicated to trace the funds to you as the applicant from time to time. And so we spend a fair amount of time thinking about how are we going to prove that the money is really yours. This is an area, too, where immigration is absolutely convinced, because they've seen it over and over again, where there's a fair amount of fraud. And so the really legitimate cases, unfortunately, are also subject to that same scrutiny, and we have some challenges in the EB-5 category. If you pursue green card based on an EB-5 investment, you are not given an open-ended green card. You're actually given a conditional green card that's only valid for 2 years. And then you have to remove the condition at the conclusion of that 2-year mark to then qualify for an unrestricted green card. Same is true, by the way, if you marry a U.S. citizen and your marriage is less than 2 years old at the time of application, you then are also granted only conditional permanent residence, and at the conclusion of that 2-year green card, you have to file another petition to prove that you're still married, or if you're divorced, you got divorced because she's terrible or he's terrible, and not because you were committing immigration fraud. But then you are potentially awarded full green cards. So same thing here, these conditional residences typically are awarded in areas where we're concerned particularly about instances of fraud, so marriage fraud and investment fraud, if we're not really confident in the scope of the investment. So the last step of green card, whether you got there through labor certification or because you're extraordinary or because you are married to a US citizen, regardless, all paths to green card sponsorship, if you're physically present in the US, will lead to this application, this I-485 application to register permanent residence. There's a fingerprinting component to green card. There's a medical exam that's required. You have to establish that you have maintained, proper immigration status and that your priority date is current, particularly in the employment-based arena. There is a priority date schedule for family-based as well. Marriage applicants are not subject to that annual quota associated with family-sponsored green card, but other relatives like siblings I mentioned before are limited by that visa bulletin. The visa bulletin that I'm going to share with you, though, is limited to employment-sponsored green card sponsorship. So I mentioned before that there are lots of different classes of green card sponsorship. So the first preference category, or what we refer to as EB1, is for priority workers. So people that are exempt from labor certification are in the first group, the first EB employment-based preference category. The other groups that are of interest to employment sponsorship, traditional employment sponsorship, are the second and third preference. So that's most of our labor certification applicants, although national interest waivers are in second preference, not first. But labor certifications tend to be either EB2 or EB3, or so second or third preference. The second preference is for positions that require at least a master's degree or a bachelor's degree and 5 years of experience. Third preference is for positions that require a bachelor's level of education. So it's not what you hold, it's not what you bring to the table as a part of your green card sponsorship. Instead, it's what does the position require. So I have lots of conversations with people who come to me before we've even talked about labor certification, jumping up and down saying, I'm EB2, I'm EB2, I'm EB2, and I say, that's awesome that you think so. We have to find out what the job is and what does the position require. So just because you have a master's degree in a relevant discipline doesn't mean that your position that you're being sponsored for labor certification is going to require a master's degree in that particular discipline. So the job drives the employment-based classification system, not your qualifications. And that is really disappointing to people sometimes, but it's important for you to know that before you get too far along in the green card sponsorship. So this is the current October 2014 visa bulletin. It is arranged along the left side by the preference category, and then across the top there are a couple of countries that are identified here. By the way, this visa bulletin and the prior slide is available on a monthly basis at travel.state.gov. That's the State Department's website. If you go to travel.state.gov and type in visa bulletin, you'll be able to find this pretty easily. So along the left side, you'll see first, second, third. That's really all we're going to talk about today. You'll see the fifth EB5 preference category there as well. And you'll see a handful of countries. So there's a worldwide quota associated with immigrant visa issuance. And in addition to that, there are per country limitations as well. So the reason why we're picking on mainland China, India, Mexico, and the Philippines is because we have a lot of people immigrating from those countries each and every year, and those countries continue to hit their per country allocation, and so they're not a part of the worldwide schedule anymore, and they haven't been. The whole time I've been doing this, they've been partitioned off. So for a really long time, we've been immigrating people from these countries. It has gotten better, significantly better. It has gotten also substantially worse over the last 20 plus years, at least that I've been monitoring visa bulletins, and I look at them pretty much every month. So we are in an okay place. We're not great, I would say, certainly not great, especially if you're from India in the third preference category. That's about as bad as I've seen, probably. Other categories are better than I've seen, so it just kind of depends. Right now, we're kind of in a unique place, and I suspect it's probably going to continue to deteriorate. So, as an example, if you are from mainland China and you are in a position that requires a master's degree, or it requires a bachelor's and 5 years of experience, there's a date there in those two columns, in the column and in the row as it comes together. That date means you had to have started your labor certification on or before November 15th of 2009 to now be eligible to file the I-485 application. So you go through labor certification, you go through the I-140 immigrant petition, and then you hang out and you wait for the opportunity to file the last step of green card. If you are from any place other than mainland China, India, Mexico, and the Philippines, and you're in the second preference category, you'll see a C there. The C means current, meaning there is no wait. Numbers are currently available to you. So as soon as you get through labor certification, in fact, you can concurrently file the I-140 and the I-485 application together. But if you are from India and you're in the third preference category, you had to have started your labor certification November 15th of 2003 or earlier. So I'm going to say something really inappropriate. If you haven't thought about dating an American, you might want to. It has to be valid, legitimate. Don't be running out committing marriage fraud, for Pete's sake. You will be interviewed. This needs to be good stuff, but it's a really, really long wait if you are from India in the third preference category. Yeah. Okay. Couple of other things. I wish I had something more interesting and hopeful to suggest on reform, but I don't. Like I said, there is no startup visa category. The annual quota for H-1Bs is terrible, and the annual quota for immigrant visa, employment-sponsored I-485 eligibility is also terrible for many of you. So there are lots of discussions going on with respect to immigration reform in connection with unaccompanied minors at the border, fences, employment verification to make sure that employers are aware of who's working for them and monitoring people who are employed, authorized to be working in the U.S. But my wish list, honestly, is very much focused on the employment side of U.S. immigration, and this is what I wish for. This is what I think about on reform measures. These are things, by the way, that don't get talked about very much in the national media. We spent a whole lot of time talking about undocumented workers, a very important topic, no doubt. But my world very much is situated here on getting sufficient numbers of H-1B visas, making green card sponsorship a lot faster and easier. I have clients who I have worked with for not quite the entirety of my career, but certainly the entirety of my time at Ice Miller, which is about 15 years. And it is very nice when they finally get to green card stage or citizenship stage if they opt to do that. One other thing that I'll mention, I'll kind of close with this. There's a lot of discussion about green card sponsorship, and it seems like a lot of people want a green card. My ongoing fear continues to be whether people really understand what having a green card is and means. There are a lot of people right now, particularly with respect to EB-5 investment, who say that they want a green card, and then they find out what that really means, and they realize, oh, maybe I really don't want or need a green card. Certainly, if you're going to live in the United States long term, you're going to want a green card because the temporary category is probably not going to be sufficient. Those cap out at 5 or 7 years, depending on the category, unless you're holding E or maybe O1. But for most of us, that's going to be limited. But for other people, they're not convinced that they want to live in the United States long term. And so I think you need to be mindful of what it means to hold green card, the potential for abandonment. If you're not physically present enough in the United States, you actually can lose your green card, and the tax consequences, the very real and very significant and substantial tax consequences of holding permanent residency status. So if you are a U.S. permanent resident, you are taxed on your worldwide income. So if you live abroad and you have businesses abroad, the Internal Revenue Service, if you hold permanent residency status, expects you to file a U.S. income tax return and report all of your worldwide income. Now, you may qualify for exemptions and credits and lots of other things that protect your income and will be beyond the reach of the IRS, but you need to consider that before you just jump in with both feet on green card sponsorship. I'm sorry?
There's a status called resident for tax purposes only that applies to non-residents within the country.
Yeah, you can be taxed as a resident. Yeah, you can be taxed under the residence rates, not just with green card status. You're right. If you've been physically, there's two tests. There's a substantial present test and a green card test. And so you're right. You're not necessarily avoiding the resident tax rate by avoiding green card sponsorship, but I do think it's something that you need to think about before you just jump in and secure green card.